Today, we will have 3 panels, and we will start with panel 3, Remedy and Protection of Vulnerable Groups. As the challenges regarding the nature of protection to vulnerable groups have significantly changed in recent times, panel 3 will give emphasis to the promotion of peaceful and inclusive societies through the protection of them by ensuring access to remedy once violation of human rights has occurred. So I will give you the floor to Betty Murungi, and you take the floor, please. Thank you.
Good morning, everyone. Welcome to today's sessions. We have a really exciting panel to kick off our day. And I'm just going to say a few words about what this panel is about. We're hoping that by focusing on the aspect of promoting peaceful and inclusive societies, we'll be able to touch on the issues that are important and really critical to do that. We all know that after conflicts, the social fabric of communities is destroyed. Environmental resources are diminished by these conflicts, and we need to understand within the context of implementing the SDG Agenda 2030 what the needs of these societies are. And by looking at the priorities that what we have come to call vulnerable communities, and even that concept of vulnerability is something that we can also discuss, what their priorities are. You can, of course, read the details of what the panel is about in your program, and I won't waste too much time on that. I want to introduce the panelists, all of them, most distinguished panelists who have done a lot of research in different fields. I will begin on my far left and introduce Dr. Siobhan McInerney-Langford. She is a senior counsel at the World Bank Legal Vice Presidency and is a recognized expert in international human rights law. She has advised the World Bank on human rights since 2002 and has represented the World Bank in a variety of human rights fora, including at the United Nations, the European Union, and the Organization for Economic Cooperation and Development. She currently serves as country lawyer for the Central African Republic and the Democratic Republic of the Congo. Siobhan is an adjunct professor at American University Washington College of Law and has, amongst other things, taught at the Harvard and UN Summer Academy. She is co-editor of a recently published book on human rights methods, and she holds an LLB degree from Trinity College, Dublin, an LLM from the Harvard Law School, and a BCL and DPhil Human Rights Law, both from Oxford University. She is admitted to practice law in Rhode Island and in the District of Columbia. Next to me is Dr. Katie Cushminder. Katie is assistant professor at Maastricht University and UNU Merit. Her research focuses on refugees and other migrants' journeys, irregular migration, and return and reintegration. You should all read her research on that. Katie's work has been published in International Migration, Journal of Refugee Studies and Migration Studies, as well as in popular outlets such as Euronews, News Deeply, The Conversation. Dr. Cushminder regularly teaches on migration at the undergraduate, graduate, and professional level. She has delivered trainings for the College of Europe, the Netherlands Ministry of Foreign Affairs, amongst other governments. On my right is Professor Sebastian Jodwe. Sebastian is an assistant professor in the Faculty of Law at McGill University, where he directs the Law, Governance, and Society Lab. He is a member of McGill Center for Human Rights and Legal Pluralism. His research focus areas include sustainable development, national law, public policy, environmental law and governance, climate change, human rights, disability, and social-legal research. Amongst other things that he does, Professor Sebastian currently serves as principal investigator for research grants awarded by the Social Sciences and Humanities Research Council of Canada. He holds a PhD from Yale University, MPhil from University of Cambridge, LLM from the London School of Economics, amongst other academic accolades. You can read them in the program. Professor Jodoin has received numerous awards and honors, including the Transnational Environmental Law 5th Anniversary Issue Prize and a doctoral scholarship from the Pierre Trudeau Foundation. He has worked at the ICTR, which is the International Criminal Tribunal for Rwanda, and the International Criminal Tribunal for the former Yugoslavia. Without further ado, I have said to my panelists that they each have 15 minutes, and they will bring to this conversation issues that you can see highlighted on the panel description, but also other issues that they may think would enrich our dialogue this morning on these really pertinent issues. And I'll begin with Sebastian. Sebastian, you have 15 minutes.
Good morning. Thank you for inviting me here, and I'm really honored to speak in front of a distinguished crowd, such as yourselves. So I'll be discussing one particular aspect of my work, which is the idea of trying to end impunity for environmental crimes in international law. So I'm going to start by giving some context on the linkages between human rights and the environment, the emerging concept of the environmental rule of law. I'll then discuss particular features of environmental crimes that make them pretty challenging to prosecute. And then I'll turn to discussing how environmental crimes are currently treated in international criminal law. So since the 1972 Stockholm Declaration on the human environment declared that humans have the fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being, there have been efforts to strengthen the linkages between human rights and the environment. This has happened in multilateral environmental agreements, but it's also happened in the UN human rights system and the regional human rights bodies. And while efforts to enshrine the right to a healthy environment in international law have not borne fruit thus far, you now have 110 countries that include this right in their domestic constitutions or in a domestic law, and an additional 40 countries that have recognized this right in regional conventions. So 150 countries have recognized in some way the right to a healthy environment. So the growing linkages between human rights and the environment have recently culminated in the UN framework principles on human rights and the environment, which were presented by the Special Rapporteur, former Special Rapporteur John Knox to the UN Human Rights Council. Now the Council hasn't adopted those principles, but they stand as a pretty good, or I should say, an authoritative statement of emerging and current practices on the linkages between these two fields. And I want to mention three principles that are relevant to the context of environmental crimes. So Principle 10, which states that states should provide for access to effective remedies for violations of human rights and domestic laws relating to the environment. Principle 12, which provides that states should ensure the effective enforcement of their environmental standards against public and private actors. And Principle 13, that states should cooperate with each other to establish, maintain, and enforce effective international legal frameworks in order to prevent, reduce, and remedy transboundary and global environmental harm that interferes with the full enjoyment of human rights. So this focus on the enforcement of environmental law is also integral to this emerging concept of the environmental rule of law, which has only really been referenced in international law and policy during the last 5 years or so, or 6 years. So in 2013, the governing body for the United Nations Environment Program adopted a decision that recognized that the rule of law and good governance play an essential role in reducing violations of environmental law and achieving sustainable development, and called on member states to reinforce international, regional, and sub-regional cooperation to combat non-compliance with environmental laws. And just recently, in January 2019, the United Nations Environment Program released its first global report on the environmental rule of law. And in this report, UNEP defines the environmental rule of law as a concept that, and I quote, holds all entities equally accountable to publicly promulgated, independently adjudicated laws that are consistent with international norms and standards for sustaining the planet. Environmental rule of law integrates critical environmental needs with the elements of rule of law, thus creating a foundation for environmental governance that protects rights and enforces fundamental obligations. And in a policy paper on the environmental rule of law, UNEP has stated that many of the Sustainable Development Goals, even those that do not mention the environment explicitly, will only be met if there is substantial progress on environmental rule of law. And this means that as countries and partners pursue the 2030 Agenda for Sustainable Development, they need to mainstream environmental rule of law into their programming. So the establishment of an environmental rule of law obviously depends upon as well as contributes to Sustainable Development Goal 16. Efforts to establish an environmental rule of law requires a well-functioning legal system that can investigate and prosecute violations of environmental laws, hold actors accountable for non-compliance, deter potential offenders from harming the environment, and empower citizens to participate in decision-making, access to information, and to seek justice in relation to environmental matters. So in 2015, the International Union for the Conservation of Nature, and it's adopted a World Declaration on the Environmental Rule of Law, and in that declaration, they recognize that states need to establish laws and mechanisms to specifically investigate and prosecute environmental crimes. And the IUCN has most notably called on states to address environmental crimes in the context of other types of crime, such as money laundering, corruption, and organized crime. So obviously this is connected to the targets in SDG 16 to combat organized crime, that's target 16.4, and to substantially reduce corruption and bribery, that's target 16.5. So in fact, illegal trade in environmental contraband, such as ozone-depleting substances and illegal timber and minerals, wildlife, and fisheries, is now estimated to be the fourth most lucrative international criminal enterprise after drug trafficking, counterfeiting, and human trafficking. And as work by NGOs such as Global Witness and Transparency International has established, these illegal activities would also not be possible without widespread and pervasive corruption. So investigating and prosecuting environmental crimes is also integral to many of the targets related to other Sustainable Development Goals. So for instance, in Target 3.9, to substantially reduce the number of deaths and illnesses from hazardous chemicals and air, water and soil pollution and contamination, you need to investigate and prosecute environmental crimes. Under Target 6.5, to protect and restore water-related ecosystems. Under Target 14.4, to eliminate illegal fishing. And under Targets 15.7 and 15.8, to combat poaching and illegal wildlife trade, you need to investigate and prosecute environmental offenses. And this can, of course, yield positive impacts, therefore, for the rights to life, security, freedom of movement, health, housing, water, food, property, and culture, by ensuring compliance with standards, procedures, and approaches, and protecting the rights, in relation to clean air, clean water, and a healthy environment, and protecting the rights of communities to access and use land, water, forests, and other resources. It's also important to note that as human rights bodies at the international and regional levels have recognized that environmental degradation and harm tends to disproportionately affect certain segments of the population due to their exposure to risk and also their underlying marginalization within society. So groups that have been singled out as being especially vulnerable to environmental harm include Indigenous peoples, minorities, women, children, the elderly, the poor, and persons with disabilities. All of these groups benefit significantly from efforts to effectively enforce environmental laws. And lastly, it's important to note that the Commission on Environmental Crimes is closely connected to armed conflicts and violence. So before, during, and after conflict, conditions of weak environmental rule of law will enable illicit and often harmful use of natural resources by organized crime or armed groups, which can fuel conflict, undermine stability, and lead to the commission of international crimes. So let me now turn to the context for and the reasons why it's so challenging to tackle environmental crimes. So there's 5 things, 5 features of environmental crimes that make them particularly challenging. The first is, of course, that economic interests continue to be prioritized over the protection of the environment in most parts of the world. And whether that's due to the straightforward effects of bribery and corruption or more subtle forms of lobbying or regulatory capture, governments have generally been unwilling to commit or invest in the effective enforcement of environmental laws. So there's a recent report by Europol which finds that environmental crimes across Europe are understood as posing a low risk of punishment, while nonetheless being very profitable. So they call them a low-risk, high-profit type of crime. Second, as this report by Europol highlights, environmental crimes are often understood by governments and the public as victimless. Environmental crimes cause harm to ecosystem and species, and its damages are often not immediately visible, and they can be cumulative. But of course, we know that damaging the ecosystem and the environment can lead to disease, lead to environmental disasters, affect the lives and health of communities. A third challenge is that technologies and behaviors affecting the environment are constantly evolving. As a result, environmental laws are always having to constantly adjust to the changing nature of environmental threats and the accelerating pace of environmental change. Fourth, environmental crimes have a transnational dimension, and organized crime, as well as multinational corporations, take advantage of the gaps that do emerge in the repression of environmental crimes committed across borders. So we see this in the numerous instances where toxic waste emerging or coming from a developed country is illegally dumped in developing countries. Fifth, the complexity and technical nature of environmental matters requires institutions, courts, and lawyers that are specifically trained for and dedicated to the task of investigating and prosecuting environmental crimes. And so we find that across Europe, for instance, the countries that are most effective in tackling environmental crimes are those that have actually invested in having specially trained tribunals and prosecutors to deal with such crimes. So let me now turn to how environmental crimes are handled in international law. So there's no single definition of environmental crime in international law, but UNEP has defined environmental crime as a collective term to describe illegal activities harming the environment and aimed at benefiting individuals or groups or companies from the exploitation of and damage to trade or theft of natural resources, including but not limited to serious crimes and transnational organized crime. So within the field of international environmental law, there are a number of treaties that impose a duty on states to create environmental offenses at the domestic level. So the Conventions on Marine Pollution, Convention on the Protection of Nuclear Materials, the Convention on Trade of Endangered Species, these are all examples. And the Council of Europe has adopted a Convention on the Protection of the Environment through Criminal Law, which has yet to come into force. However, the EU has a directive that is basically the same that has been implemented by member states. And both of these instruments provide a list of the types of environmental offenses that, in Europe at least, now through this directive, states must criminalize, investigate, and prosecute. So in international humanitarian law, in arms conflict, we have a number of provisions that also prohibit or criminalize harm to the environment. So Article 35.3 of Additional Protocol 1 states that it is, and I quote, "It is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment." And by the way, the United States, France, and the United Kingdom are all persistent objectors to this article. And they reserve their right to use nuclear weapons, which obviously are destructive to the environment. Meanwhile, the Red Cross has concluded that this rule is now part of customary international law and that it applies to both international and non-international armed conflicts. You also have a convention on the prohibition of environmental modification techniques in armed conflict. And the Chemical Weapons Convention also requires states to enact penal legislation to ensure that individuals within their jurisdiction who act in breach of its obligations are punished. Okay, now turning specifically to the field of international criminal law, Some of you will be familiar with an article in the Rome Statute, which, similarly to the article I mentioned in Additional Protocol 1, criminalizes intentionally launching an attack and the knowledge that such an attack will cause widespread, long-term, and severe damage to the natural environment. However, the Rome Statute adds an additional clause to this, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. However, the reach of this article is pretty limited because the provision only applies to international armed conflict. There's also a number of other war crimes within the jurisdiction of the ICC, which could apply to serious environmental damage, where that was caused in conjunction with harm to civilians or civilian objects, so including the crimes of destruction of property, civilian objects, employing poisonous weapons and gases, and internationally starving civilians. A number of crimes against humanity could also provide ways of criminalizing and punishing environmental damage, where that damage was inflicted as a means of causing suffering to human population. So for instance, if you're destroying the environment as a way of deporting or forcefully transferring parts of the population, or where you lead or where destroying the environment leads to murder or extermination, then this could constitute a crime against humanity if it were carried out in a widespread or systematic manner. Finally, the use of environmental destruction to cause serious harm to national, religious, racial, or ethnic groups could also constitute the crime of genocide if you meet the requirements there. So, to date, however, there have not been any prosecutions of environmental crimes under the ICC. Recently, in a policy paper, and the only prosecutions we have really of environmental crimes date back to Nuremberg and the World War II context. Recently, in a policy paper on case selection and prioritization, which was released in September 2016, the Office of the Prosecutor indicated that it would consider crimes committed through or resulting in, and I quote, the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land. So this policy paper attracted lots of media attention. In The Guardian, I think they wrote that now environmental defenders were at risk of being brought before the ICC. And of course, the Office of the Prosecutor has received many communications alleging crimes relating to the environment. However, in practice, the limited scope of the relevant crimes within the Rome Statute means that really the prosecutor is unlikely to launch cases relating to environmental harm because the only cases that she can initiate must fall within the context of an armed conflict or the large-scale or systematic behavior that underlies crimes of genocide or crimes against humanity. So perhaps I'll end there, but I have some thoughts as to what could be done, and maybe we'll have more discussion on moving forward. Thank you.
Thank you, Sebastian. Indeed, we shall have time to follow up on some of the important issues that you raise. I'll just now turn to Siobhan. You have 15 minutes.
Thank you, Betty. Thank you, everybody, and thank you to the organizers. I'm very pleased to be here. These remarks that I'm about to share with you are being shared in my personal capacity. I do work at the World Bank Legal Department, but as you'll appreciate as the comments go on, these are not an institutional view. I have three sets of remarks. First is some reflections on the relationship between human rights law and development, so really looking at it through a legal lens, public international lens. Second is considering the issue of accountability, legal accountability in development and in the SDGs, and also looking at challenges and opportunities with the 2030 agenda as it's been formulated. So first, a bit of context. As many of you will know, the relationship between development writ large and human rights is fraught. I think that's a polite way of saying it's been really difficult for a really long time. It's been broadly an account of both convergence but also divergence. Philip Alston used the metaphor of ships in the night, and while it's been used a lot, I think it's still true to some extent. Notwithstanding that, there are, as I say, points of convergence and even overlap, and definitely potential for complementarities. And certainly in the work that I've done, seeking out those complementarities, including in the frame of public international law, has been an important objective. So a legal appraisal, though, of that relationship between development and human rights, I'm afraid, is even more sobering, and in my view, illustrates greater convergence. The reasons for these are several, but one observation is that there are significant qualitative differences between the frameworks that govern in development and those that govern in human rights law. I'm thinking specifically of, yes, MDGs or SDGs, Paris Declaration, the sorts of frameworks and partnership documents that are routinely used in the development sphere rarely have an anchoring in treaty obligations. I think also development and human rights, while they have at an intuitive level some common purposes, they were designed with different aims in mind. The SDGs, for instance, focus on eliminating poverty. Human rights law is perhaps more about accountability for specific legal entitlements. Human rights would focus on non-compliance, where in the world I occupy, where I work, we're talking about economic growth and incremental change. There is also the dimension of development still being conducted in a horizontal way, state to state, while human rights will scrutinize the relationship of a member state or a state party with its citizens. Having said that, there are obviously an important body of soft law instruments that have been developed over the years that would speak to greater convergence. So the Proclamation of Tehran, obviously the Declaration on the Right to Development, the Vienna Declaration and Programme of Action, and then more recently the Millennium Declaration in 2000, Rio +20, Vienna +20, and other soft law measures, including the action-oriented policy paper of the OECD DAC in 2008, and a number of other measures that, or instruments that were adopted in the context of aid effectiveness. The reasons, as I mentioned, for the divergence that I observe between human rights law and Agenda 2030, I think relate to the fact that human rights and development still illustrate or reveal a different evolution. There is a general neglect of public international law in development. It's dominated by economists, as most of you will know, and I can tell you from experience you have to argue for the relevance of public international norms in operational terms. There's also obviously in parallel or in a more general sense the proliferation of international norms and frameworks, as well as large bureaucracies and rules that have been built around those, which has resulted, as was discussed yesterday, in silos or fields being quite separate and disciplines that don't really speak to one another anymore. I think in the context of development and human rights, that fragmentation may be exacerbated precisely because the development frameworks in question are not treaty-based. So I would argue that this results in a lack of international policy coherence, concretely a lack of entry points in operational frameworks, institutional policies or mechanisms, and a general lack of understanding of the relevance of public international law and human rights law to development, and even a caricaturing of what that might mean. So, for instance, reducing the relevance of human rights law to naming and shaming. I would like, before going on with the thoughts I have, the reflections I have on legal accountability, I'd just like to mention where I think an eagerness to find common ground and identify convergence is problematic. I think first there is an inconsistent treatment of human rights in development, even though development has now moved into spheres that are very clearly occupied and governed by human rights treaties. There's also a phenomenon which Peter Uven called rhetorical repackaging, and that can look like mission creep by large development actors and renaming concepts that are fundamentally human rights concepts. What you often hear is, we're doing it already, which I think, again, completely subverts the nature and purpose of human rights law and human rights accountability. And all of this ignores the fact that human rights law obligations have, by and large, not been received into development frameworks. And I maybe spend a little bit of time on what I mean by legal accountability, which is something I've thought about a lot as a way of tackling the divergence and potential convergence of development and human rights. I think legal accountability is both the essential and distinct element of value added that human rights law can offer development and the SDGs, but it's also potentially the very reason that human rights law is resisted in development circles. I think that's related also to a general discomfort with legal accountability and outside legal scrutiny of development agencies. So what do I mean by human rights accountability? I'm keenly aware that I'm in a room full of lawyers, so there will probably be as many definitions of that as there are of you here. But at base, when we think about human rights and think about what makes them special or different, it's that they imply duties. And through law, they impose legal obligations for both process and outcome. They make entitlements the subject then of legal obligations. And as I mentioned earlier, human rights law operates in its distinct way vertically between a member state and its citizens, as well as, of course, the compact that the member states or states parties have between themselves. Obviously, there are different definitions. In my work, I've tried to explain it, especially to economists, in the following ways. That accountability on one definition might comprise three elements. That you would have a norm, information and dialogue around that norm, and a consequence or sanction if it's violated. Other elements could be public justification based on reasonable and objective evidence, alternatives being examined, transparency and participation, consideration of direct or indirect discrimination, minimum levels of an entitlement or right being ensured, and independent review. Another way to think about it is that accountability requires answerability of those in power. I would argue that under the SDG framework, we really don't have accountability that would satisfy any of those definitions. And so what Sam talked about yesterday about the legal depth of the SDGs not mattering, I would take issue with. I think the legal pedigree of these norms matters a lot. That's not to say that I don't think they have value, which I'll get to in a moment, or that they shouldn't be invoked, which is what he said. I think we should invoke them as much as we can where they're relevant. But my concern there is, what is the remedy or consequence if we fail to meet the SDGs, as some would say we fail to meet the MDGs? Let me turn now for a moment to how these considerations and grumbles apply or don't apply to the SDGs. I think there's a clear advance in the SDGs. I wouldn't like what I'm about to say to be misunderstood as not recognizing the advance that it represents, that the framework represents and the goals themselves represent. Nevertheless, there are challenges. The list, by some accounts, is over-inclusive and too long, sometimes compared to a Christmas tree approach, that it would be impossible to achieve, that it's vague and aspirational, and that it's toothless, that there's no accountability, and in that respect, that it suffers the same weakness as the MDGs did. Nevertheless, I think it would be unfair not to recognize that the SDGs are more human rights friendly. But again, from a formal legal appraisal of the goals, the references to human rights in the Declaration, so the Transforming Our World, are a General Assembly resolution and recall an uncomfortable parallel, I think, with what occurred with the MDGs, where we had the Millennium Declaration, a positive manifesto for human rights, and then the goals, the MDGs, neglecting human rights altogether. Second, there's no binding legal anchoring of the SDGs in human rights law, notwithstanding the preamble, and this has been the subject of a lot of debate and argument among those of us who work in this space. No general reference to human rights obligations as such in the goals, and no freestanding human rights goal among the 17, although I know that that was a deliberate, and that it was actually the advice of the Office of the High Commissioner not to have an isolated goal, but to attempt rather to integrate and mainstream human rights throughout the 17 goals. So in my reading, and from a strict legal point of view or a legal appraisal, the SDGs do not fulfill the accountability promise or potential of human rights law. That said, the SDGs do cover, in substantive terms, far more human rights terrain than the MDGs did. We're seeing what would be the equivalent or analogue of covering process rights, civil and political rights, to a greater extent than the MDGs, although that wouldn't be hard given that they didn't cover them at all. But We have participation clearly hardwired into the SDGs. We have a clear concern with equality and inclusion in Goal 5, 8, 16, obviously, and even 11. And then accountability to some extent to give Goal 16 its credit. But let me conclude by thinking about how all of this applies in the FCV context. This is something we've been thinking about a lot in the World Bank recently, or in the last 5-7 years. As most of you will know, working in what we call FCV, so fragility, conflict, and violent affected states, has become a corporate priority, and we have a strategy, a new strategy on FCV expected this year. Goal 16 recalls the importance of institutions of accountability, as we had done in the World Development Report in 2011 and in the Pathways for Peace report in 2017, both of which underscored the importance of accountability and redress and human rights in predicting violent conflict or the risk of violent conflict, responding to it, and prevention, of course, of its recurrence. As most of you will know, the Pathways of Peace report was laden with human rights references, which we considered quite an achievement. It even has a box on human rights as a basis for normative change, as well as a box that I'm also very proud of on public international law and armed conflict, because it was a real battle to explain to the team, although they were receptive, why would we have a box about law? So, what can we do about this? I leave you with 5 ideas. First, that we should keep pushing for the recognition of the application and relevance of human rights law obligations in development spheres. And put simply, it is that the same member states that have taken on obligations in the aegis of the Human Rights Council also participate in the boards of international financial institutions, but for some reason there's a disconnect between the voice and rhetoric one will hear in the human rights sphere compared with what one will hear in the development finance sphere. Second, to consider empirical approaches. I'm not suggesting that we have the data that we need to make the case to an economist, for instance, but there's enough good research out there that looks at what works in terms of commitment and then compliance. Somebody had raised this yesterday. I'm thinking of the research done by Una Hathaway or Beth Simmons, looking at the real impact of, for instance, ratifying the Convention on the Rights of the Child relative to rates of immunization in a country, notwithstanding the causality issues and attribution. Third, explore the relevance of human rights as a risk mitigation factor, particularly in FCV. This I've also found persuasive, and I think we can learn a lot from the world of business and human rights and the guiding principles, which put front and center this concept of human rights due diligence. One could even try a normative approach, because some of these people have a moral compass too, and that it's the right thing to do. But finally, I found that the simplest and best answer to why is human rights law relevant and why should we integrate it to some extent or at all is that it's the law. So that's the simplest and most effective answer in my view. Thanks.
Thank you, Siobhan. You can switch off your mic. Thank you very much. We now turn to Katie. Katie?
Thank you very much, Betty. And thank you very much to the organizers for having me here today. It's a real honor to be at this venue and in this courthouse and speaking at this conference. I do just want to say that I'm not a lawyer, so my intervention will be, I think, quite different. My work is on the experiences of migrants and refugees, and I do a lot of interviews with them at the micro level to understand what they're going through and their migration journeys. So today I'm going to make 3 points. I first want to talk about the changing policy context for migrants and refugees, particularly for those making their journeys and coming to Europe. I second want to talk about some of the experiences within those journeys that migrants face. And then third, I'm going to come to the point of institutions and justice, where I will probably pose more questions than answers in this field. So just to quickly clarify, what's the difference between a migrant and refugee? I imagine that many people know this at a high level, but I just want to just restate it for anybody who might be unclear today. A refugee is, of course, a forced migrant fleeing violent conflict or persecution. But refugee status is quite where the confusion, I think, often comes in, because people can be given a recognition by the UNHCR. So, for instance, a refugee going to a near country can have a recognition of being a refugee, but this doesn't necessarily provide them with rights within that country. And as soon as then they again leave that refugee camp, or if they start on another journey, they more or less become an irregular migrant because they have not gone through a refugee status determination procedure. So it's not until people come to countries that recognize the UNHCR Geneva Convention, the United Nations Geneva Convention on Refugees from 1951, and they make a claim for asylum, and that claim is approved, that they become a refugee with recognized rights, right? So this is often quite confused. And migrants then are people who have different rights than refugees. They're people who come for other reasons. They might be leaving their countries for other reasons, but they're not recognized as refugees. And this becomes quite confused within the journeys, because what we talk about today are mixed migration flows. And as I talk to you about these flows and people transiting through countries like Sudan and through Libya, there becomes a question of, does it really matter what reason they're fleeing from, if their experiences are the same, and if the conditions they're facing are the same within these countries. So this is a little bit about what I wanted to talk about as well today. So in terms of policies within the European Union, the trend and focus in Europe has become towards preventing people from accessing the European territory and what we call the externalization of the EU border control. This means that progressively migrants are controlled and prevented from entering Europe further afield. 10 years ago, when we talked about externalization, this was to countries such as Morocco and to Turkey. But from 2016, this has moved much further south, and it's now in Niger, where we see the active prevention of migration. It's in Sudan, and most concerningly, it's in Libya. And this is demonstrated, of course, by the Libya-Italy deal, and also by the EU-Turkey deal, where Turkey has taken on a much larger role than ever before. And this is quite concerning when we think about EU migration control, and what does this mean? And there's a scholar from Norway, Jan Paul Breck, who terms this responsibility without control. And what he means by this is that the EU is directly funding and cooperating with these countries, but without having control over the rights, safety, and access to justice of these people. Their safety and their rights are being determined by the powers of Turkey, the powers of Libya, and the powers of Sudan, which we know, particularly in the case of Libya and Sudan, are fragile states that do not have much access to justice for their own people. I also want to make the point that as an example of what's happening to people in these countries, we of course have the media, who has been giving us a lot of representation, but we talked yesterday about data, and data on access to justice and data on access to experiences. And again, this is of course not the A-level necessarily quality of data, but there is a lot of data. There's data collected, for instance, by the International Organization for Migration Displacement Tracking Matrix, which tracks and interviews refugees en route, migrants en route, and asks them about their experiences of exploitation, kidnapping, death that they have witnessed. So the Danish Refugee Council 4MI data, which does something very similar to this. Within the past 3 years alone, the World Bank, the IOM, the UNHCR have all conducted large-scale surveys in Greece and in Italy on migrants' experiences of coming. And this is excluding all the research conducted by numerous academics who have been working on these issues. So I do want to say we do have a lot of evidence. As one small example of this evidence, the UNHCR survey in 2017 with Eritreans, Ghanaians, and Sudanese who had arrived in Europe found that 64% reported having suffered physical abuse, violence, or torture, including sexual violence. 45% reported being subjected to deprivation of food, and 41% to deprivation of water. 30% reported having been subjected to exploitative labor practices, and 21% reported experiencing extortion or corruption. So we do have evidence, and we do have knowledge that this is happening. So this takes me to bringing you into further the second topic I want to talk about, which is migrants' experiences on these journeys. And I'm going to share with you some examples from my own research of Eritreans' journeys from Eritrea to Italy. And when we think about these journeys are staged. So they happen in multiple components, and they happen over longer periods of time. For Eritreans, the first step is, of course, fleeing the country, which is in itself a very risky endeavor. There is a shoot-on-sight policy for the Eritrean army to kill people as they're trying to leave the country that don't have a valid exit visa to do so. So this first stage of leaving the country is itself risky. It's often conducted in secrecy. It's conducted in the night as people try to evade the authorities to leave the country. The first points of entry is into Ethiopia or into Sudan. It used to be, about 5 to 10 years ago, that Eritreans in Ethiopia had the opportunity to apply for resettlement to go to third countries such as the United States. And this was really essential for providing hope, and a fair number of Eritreans were resettled each year from Ethiopia to countries like the US. This has all stopped now, and it's increasingly recognized by Eritreans in Ethiopia that the degrading conditions in camp, the high prevalence of disease, lack of enough food aid has created deteriorating conditions that they do not see a future for themselves. So after some time in Ethiopia, they recognize this and they move onwards. It used to be in Sudan 5 years ago that Eritreans could also create a business, have a productive life there. But conditions have also changed in Sudan. Women that I spoke to and respondents increasingly talked about violence that has increased towards Eritreans in Sudan. They flee the police, who will openly beat Eritreans in the street. The papers they receive are very temporary, and they can be taken away at any time. And they do no longer feel safe at all in that country. For example, one woman who was 8 months pregnant in Sudan was crossing the street, and she was stopped by the police. The police beat her, and both of the children that she was carrying were killed. The next time she became pregnant, a few years later, she said, "I knew immediately I had to leave because I did not want to place my child at risk." So Eritreans feel that they cannot stay there, and they seek to move onwards. Eritreans know, and I think it's really important to stress, that they know and they're heavily aware of what will happen to them in Libya. In Libya, they know that they will be kidnapped, that they will be extorted for ransom, and they can only be released from the kidnappers in Libya once their families have paid the ransom for money. They have known this for a long time. They have known this from around 2013 to 2014 when this system started. And what has happened in Libya is that with the fall of Gaddafi, the Tibu tribe has taken control of southeast Libya. And the kidnapping and extortion of migrants has become a central source of profit. And for Eritreans they enter from Sudan to this part of Libya, they all pass through this territory. So it's a different situation than migrants that come from Western Africa and then enter from Niger to Libya. They're entering in a different route and a different controlled territory. For Eritreans, it's very specific for the territory that is controlled by the Tibu tribe in Libya. And when I spoke to Eritreans, they know that this will happen, and some people have started to create strategies of how to get through the kidnapping and ransom more quickly. And I can give you one example of a woman that I interviewed who said to me she knew she wanted to go, and she was waiting to go until she was ready. And she had an uncle in Israel who she was hoping would help her with the payment. And she spoke to the uncle, and the uncle said to her, "I do not want you going this way, under no conditions. There's a flight now from Khartoum to Tripoli, and I want you to take that flight. It's more expensive, but I'm saving my money, and as soon as I have enough, I will let you know, and you can take this flight." And as soon as she heard this, she said, "Great, uncle is saving his money, and I have the opportunity to go. He can pay now." So immediately she left. 2 days later, she had a friend call to her uncle and tell them that she was going. She went, she was kidnapped. Because the friend had phoned the uncle had prepared what he had, that money was sent, and she was in and out of Libya within 1 week, which is really a very fast pace. Most migrants and Eritreans are kept in Libya for a month or longer until their families are able to pay the ransoms. So it's really important here to stress that what is happening with Eritreans going through this route is not human smuggling, and it's not human trafficking. And the reason I say this is because it's very often portrayed as human smuggling or human trafficking. And it's portrayed as human smuggling from the EU saying we must stop these violent criminals who are smuggling migrants and prevent these flows through these different mechanisms. Human smuggling is an agreement between the two parties. It's an agreement between the migrant and the smuggler that I will pay you X amount to take me from A to B. It's important to recognize that very often from migrants' perspectives, Smugglers are not the enemy. In South Sudan, they were often called the freedom fighters. They're the people who can get you out of a bad situation, so they're often reliant on them. And the majority of human smugglers around the world are very small scale. They're people taking people from one location to another that's often a short journey. So people often use multiple smugglers to get from A to B on a much longer journey. This means that they're often not large-scale criminal networks, which is often how this is portrayed. So what's happening here with the Eritreans is not human smuggling. And it's also not human trafficking, because human trafficking requires that there's deception, that there's coercion, that there are elements happening against the knowledge and against the right of that individual. Eritreans know what will happen, and they're willingly going into these situations, not because, of course, they want to, but because they don't feel that there's any other options. So again, this is not human trafficking, and we need to recognize that. So what is this? I will talk about further when we come back to justice and rights. And I just want to provide one other small example, because Eritreans are a group that have a 90% recognition rate in the EU for refugee status, so we can consider them very much a refugee group. And I want to contrast this and also share, though, with a short example of migrants' experiences. And here, I will also talk about Ethiopia, but I'll talk about Ethiopian women that go to the Middle East for domestic work. And there's a very good scholar from the Netherlands who is a lawyer who has done a lot of research on domestic workers' rights in Saudi Arabia. Her name is Vervliet, and she has said it's very clear that domestic workers in Saudi Arabia have no rights. The best they can hope for is to be treated right by their employers. And the women that I interviewed in Ethiopia had returned from the Middle East, so they were all returnees, and they all said that when they went, they knew that what could happen to them. They'd heard the stories. They were aware that they might be abused by their employers, but they hoped for the best. They hoped that God would protect them, and they hoped that they would have a good opportunity. And they didn't feel that they had any other opportunities in Ethiopia. They needed to provide for their families, so they took this opportunity. The majority of women that I interviewed did experience some form of abuse. Most commonly, the forms of abuse they experienced were such as deprivation of food. Many women were only fed once per day and not more than that. They experienced injustices such as not being allowed to leave the house or have any social networks, so not being allowed to contact their families, not having access to a mobile phone. And these were also very serious situations that when they returned home to Ethiopia has left them with a lot of trauma, and it's a very difficult then experience of reintegrating back into society and creating a healthy life upon return. So when we consider these examples, then I do want to return to the topic of what are the institutions to promote peace and to protect refugees and other migrants. I think here that there's a huge gap to fill, and I do want to stress that this is not my area of expertise, so I will pose some more questions than not. Refugees are protected by the 1951 Geneva Convention on Refugees, but who monitors and enforces this convention? It's been widely discussed by legal scholars in Australia that the offshore processing of asylum seekers is a violation of the Geneva Convention. In Europe, there are also arguments that the EU-Turkey deal violates this convention because both of these agreements remove the right to apply for asylum on those countries' territories. There is questions about, then, is asylum a human right to apply for, or is it not? And where is the accountability within these mechanisms? We also know that in Libya, the conditions in the detention centers are horrific. Italy is actively funding to return boats to these centers where people are placed in these detention centers. We know that there are gross human rights violations occurring there, so what also then is the accountability in this situation? Particularly, I do want to stress again, when we consider that many of these people are Eritrean refugees, where we know would have a very high recognition rate for being a refugee if they were to make it to Europe. I think also yesterday, Betty, you posed the question, what is justice for refugees and other migrants in these situations? And I think that's a very difficult question, but from the refugees and other migrants that I've interviewed in my career, I can say that what's most important to them is what's right in front of them. And what's right in front of them is what they need today, which is safety, dignity, and security. What's most important to them is legal rights. And this includes, in whatever context that is, their papers. So for people coming for asylum seekers in the EU, they want to know that they have papers and that it's secure. Even for people then who have received an initial temporary status, they want to know that the next status is secure and that they're not going to be returned or deported after 3 years when that status expires. For people in near countries of reception, they also want to know that they have a right to status, that they're not just going to be living in refugee camps. Whether this is a right to local integration and naturalization within that country or to third country resettlement, they want to know what's happening in the future. And I think as just a final point, when we think about this, that I can maybe quickly make, that is the other major concern about what's happening today, is the rights of the Rohingya refugees in Bangladesh, when we consider that there's close to 1 million Rohingya in Bangladesh. And what we see now is reports of Rohingya fleeing the refugee camps because they fear being forcibly returned to Myanmar. And I think this is a big issue when we think about return and repatriation and about what will happen for the future of this population. So it's very clear that there's a need for increased global solidarity on migration and refugee issues. More support is needed to people in these situations. The global compacts on migration and the global compact on refugees are very strong steps in this area. And we will see if and how they improve conditions for refugees and other migrants in the years to come. Thank you.
Thank you, Katie, and thank you, Sebastian and Siobhan, for elucidating the subject before us and bringing these examples and really highlighting things we need to think about. I know you're all sitting there thinking, oh, but they didn't talk about the right to remedy and reparation, and they didn't talk about how the SDGs are going to strengthen state responsibility to victims of conflict and victims of violations. But this is going to be weaved into their responses. And we were thinking that because we're always talking about the right to a remedy and reparation, it's something that we all know, and it's something we've discussed over many, many years. And so we thought these questions around the failures in environmental rule of law, the failures of enforcement, the nexus between human rights and development, and the issues that of refugees and migrants that Katie has brought to the table provide us with a really interesting launchpad for us to get into this conversation on remedy and reparation. So we have 35 minutes for this conversation, and I'm going to turn it over to you. Do not feel constrained just to ask questions, but also to contribute. Let's hear your comments. If you need clarifying issues from the panelists, then feel free, because this is a dialogue. I see a hand right at the back. Please limit your intervention to 1 minute, 1 minute.
Hi, Suzanne Schmeidel. I'm also not a lawyer, and I've been listening. I'm a sociologist. I teach development studies at the University of New South Wales in Australia. I've been listening a lot to you as legal profession or lawyers looking at development. What I've been missing a bit is some of the engagement to look at that. Even in development, there is something called critical development studies, like there's critical peace studies as well. And there's been a lot of critique of the macro level development policies, and the SDGs are macro. They're mainstream, they're created by large states. There's been no reference to, for example, the work of Mary Anderson of Do No Harm that is trying to work to adjust some of the responsibilities that development actors have for doing harm, and there's ethics in development, etc. What was very welcome was Siobhan, that's about legal responsibility, but then I would ask the question, who are some of the biggest perpetrators or have been the perpetrators? You could count the structural adjustment policy by the World Bank. We in critical development studies would see that the World Bank, some of the large, multilaterals have been the perpetrators in violating rights. Who gives most of the money in development assistance? We've heard it as states. Afghanistan is an example of how aid has probably deteriorated a pretty okay situation. There is a lot of evidence by Zigar, the Special Investigator General for Afghan Reconstruction, about how aid has done harm in Afghanistan. Now, is anybody going to prosecute the United States? That's my question to you as the legal professions. Yes, it's about legal accountability. All we can do as non-lawyers is try to adhere to do no harm, context sensitive, and ethics in development, and we've done our part in that. But my question to you is then, how as lawyers can you strengthen it? Because who's going to prosecute the large states that will continue to do the violations? Because they talk about aid accountability, but that's about money spent. It's not about whether or not you have environmental damage, whether or not you regress in human rights, or whether or not your own implementing partners violate certain rights.
Thank you.
So that'd be, for me, a welcome, because I do think there's a lot of work been done that could be engaged with.
Yes, Robert, and somebody else?
Yes, thank you so much, and thank you so much for the presentations. Looking at the topic, remedy and protection of vulnerable groups, I'm thinking, apart from environmental law defenders, refugees, could we have maybe the top list of 5 vulnerable groups? Because at some point, we all seem to be vulnerable on issues of justice, and in relation to the work that we do and the discussions that we have, at some point we feel like there's a degree of vulnerability. So when we say remedy and protection, who are these vulnerable groups that we are really talking about in terms of the SDGs and also international justice? About refugees, you realize that there is some exposure of the local communities, because when these people come and settle or are trying to seek asylum, and then we have this high protection for them, the communities the communities that they have joined, again feel like they are being treated unfairly. Because these people come, they have protection, they have the food, they have all the assistance they need, and we tend to forget the community members whom they've found in those particular areas. I don't know how you're working around seeing that there's a balance so that these people don't feel like we are giving much attention to the new groups or the refugees that have come in and forgetting their rights. Yeah.
Thank you, Robert. We'll hand it to you.
Good morning. I'm Melanie Wunsch. I work at the Federal Foreign Office. Thank you very much for this interesting panel. My question is to Siobhan. You talked a lot about the divergence of human rights and development, and you talked about what human rights law can do for development, for the development field, which is mainly accountability. But in your view, is there anything the SDGs, the Agenda 2030, can do for the fulfillment of human rights? I'm thinking, for instance, when talking to states like China, which keeps stating that development comes first and then human rights implementation. So I'd be curious to hear about your views on that.
Do the responses. We'll start with Siobhan. Sebastian?
Katie, do you want to start?
Sure. So I think the only question for me was about local communities and host communities. And I completely agree with you. It's also a core area of interest. In the past, you are right. There was very much a strategy of, it's emergency humanitarian support to provide some shelter and some food to the people who are first coming. But as situations become more protracted, then there's a huge responsibility on host communities. There's increasing research looking at different models of hosting and refugee hosting because, of course, 85% of the world's refugees are hosted in the global south. It's a huge burden on these countries, right? And different models have shown different levels of success. If you look at programming today from organizations like the World Food Program, the UNHCR, they tend to mostly include an element also for local host communities so that they can try to create some more equalization in terms of their shelter programs for access to shelter, in terms of food distribution, that they're targeting both. If we look at examples in Ethiopia, the Comprehensive Refugee Response Framework, It again aims to target both hosting communities and refugees. So I think this is definitely a recognition that is increasing and something that is changing. But it is still very difficult in terms of how people are hosted and the access. I mean, research also in Kenya has shown that hosting in the camps, people are very restricted, right? They're not allowed to come in and out. And this also then creates a burden in terms of having any local integration and having a positive relationship between the two groups when they're restricted in their movement and they're not able to move. But we do know that very often refugee hosting can also increase livelihoods for host communities because it does bring more people to market, it does bring more access. But of course, there's negative consequences such as degrading resources. So I don't think that's a very final answer to give a big end, but I agree with you, host communities need to be considered. I think they are more and more. Whether it's enough or not, I think is still debatable, and it is an important area for consideration.
Thank you, Katie. I just want to say that in reference to some of the Robert's question around vulnerable groups and vulnerability, you know, of course, that conflict causes vulnerability to particular groups. For example, women are not inherently vulnerable, but they become particularly vulnerable during situations of conflict because of the exposure to violence. Protected groups such as children become more vulnerable during situations of conflict and after conflict because of this exposure to violence. So the protection for these groups then becomes extra important, and in terms of thinking through, you know, what remedies would be available to them in those kinds of contexts. Are you ready now, Siobhan?
I'm ready now. Those were the two questions that I think were directed to me. I really appreciate them. The first on criticisms of the SDGs as a macro policy, I couldn't agree with you more, and the spirit of my remarks was very much in that vein. I think the fact that, I mean, the reasons for which I think there are solid human rights critiques of the SDGs are precisely the points that you've been making, and the point I was trying to make about the lack of accountability that I think of as adequate. When I think about accountability for development, I suppose I'm in two minds. As a human rights lawyer, I'm not satisfied at all, and I think that it's odd that we tolerate this sort of disjunctures and lack of coherence that are extant in the international system. And then, in a more balanced and pragmatic spirit, I think we have to look at how development institutions have reacted to calls for greater accountability, and to see that internal accountability mechanisms exist in almost every one of the multilateral development banks, and that those do work. They may not be the sort of grand, if as a formal legal matter, they may not be satisfactory, but they do provide voice and recourse, and some of the elements that I mentioned earlier relative to the meaning of accountability, I think, would be satisfied by a number of these. I'm thinking about the World Bank Inspection Panel, the IFC, CAO Ombuds, and the various mechanisms that exist in the Asian and African development banks. So just to sort of give a balanced response, there is accountability, and even at the micro level in projects, it's become a practice to have a grievance redress mechanism and specific tracks within those for instance, gender-based violence. So the calls for accountability have not gone unheeded. I suppose as a human rights lawyer, I'm trying to remind them that there's also accountability under these treaties, which we've conveniently neglected. I really like this question about what the SDGs can do for human rights, because I've always thought about it the other way around. And as you were asking your question, I was thinking that maybe it's a cynical view, but the SDGs, in all of the ways that they represent an advance and in the ways that they clearly reflect human rights principles, they may be able to do the work for us in some way and make the case for models and approaches to development that emphasize institutions that recognize the central importance of inclusion and equality and even participation. So I think that there may be a case to be made that the SDGs, as they currently are, can do some of the work for us without using the language of human rights that's so scary to so many people. But then I get nervous about when we start doing it already without using the language of human rights, whether we do violence to it in the end, and how, like, it's a slippery slope. Where do we stop and say, well, no, hang on, that's not really human rights, that's something else? Thanks.
Yes, so I guess in terms of critiques of development and their record on human rights, like I should mention, I've written a book which looks at the human rights implications of a climate finance mechanism that the World Bank, UN RED, and other countries set up to combat deforestation in developing countries. And it's called RED. It's another acronym for you to learn if you want. Reducing emissions from deforestation and forest degradation. And then there's a plus sign, which I won't get into, but RED plus. And so I looked at the implications of this mechanism on human rights, and both in the way in which the different multilateral and bilateral programs integrated human rights norms. And then I did some field work in Indonesia and Tanzania to see how those norms had then been, whether they'd been recognized and protected at the national level and also at the project level. And the story is one of nuance. There were definitely projects and different ways in which programs did not fully uphold the rights of indigenous peoples in relation to their rights to free, prior, informed consent and their resources and land. And I also found really surprising things where indigenous activists in Indonesia said, "Oh, we've accomplished more since the Norwegian government signed a letter of intent with Indonesia to combat deforestation. We've made more progress on indigenous rights through that mechanism than anything else in the last 20 years. And so this is kind of an interesting result, which is that there, in fact, sometimes maybe there are advantages to working a little bit indirectly on these things, right? So, if someone from the High Commissioner for Human Rights comes to Indonesia and says, you need to do a better job on indigenous rights, well, that has a particular response versus, hey, we want to help you combat deforestation. Here's this money. Here's this program. Oh, we have these safeguards over here. Oh, we're going to give money to these indigenous people so that they're adequately consulted. And you're actually not working with lawyers. You're actually working with people who are trying to manage programs to combat deforestation. And you get to a very different result, including documents where for the first time the Indonesian government recognizes the Adat communities as indigenous peoples, even though its Foreign Affairs Ministry still claims that there are no indigenous peoples in Indonesia. So you have this interesting result. So I don't think it's all bad, and in fact, I think that we've seen a lot of progress in how these different multilateral and bilateral agencies are addressing human rights issues. On the issue of vulnerable groups, I just want to mention that in the field of environmental harm and climate change, we have this particular approach to understanding vulnerability. And so vulnerability is understood as the relationship between your exposure to risk because of, for instance, let's say you live on the coast, you're more likely to be, you're more vulnerable to floods, for instance. So there's the underlying exposure to risk. But the second element is what we call adaptive capacity, which is your ability, what the assets and entitlements that you have, and the ability that they give you to adapt to change, to be resilient to harm. And so it's really interesting to look at vulnerability through both of those lenses, because it helps you clarify between, all right, these people are vulnerable because they live in an area where there might be droughts, versus these people are vulnerable because they're marginalized, because their rights are not protected in their countries, because they are systematically discriminated against. So in that sense, I think it's very interesting to think about that. And in the climate change context, which is one of my areas of work, the list that comes up in resolutions, both in the Paris Agreement and in the Human Rights Council, will say, climate change has a range of implications for human rights, and then they'll say its effects are felt most acutely by, and so the list there is women, the young, indigenous peoples, and persons with disabilities.
Thank you. We'll take another round before I ask the panel to, yes, Dr. Ramcharan.
Thank you very much. I wonder if I may just pick up the point of what can the SDG do for human rights. And from the point of view of the title of the panel, Remedy and Protection of Vulnerable Groups, if one asks, historically, are there examples in which the international community has identified groups and gone in to seek protection of groups? One could perhaps refer to the League of Nations experience, abandon on the protection of minorities. One could look at the United Nations creation of the Working Group on Indigenous Populations, which became then the Permanent Forum on Indigenous Populations. One could think about the protection of slavery. One could think about highlighting the issue of female gender mutilation. Yeah, how this came. So therefore, it would seem to me that apart from the rather good discussions we've had there from the panel and from the floor, this one approach to this is the identification of groups that are in need of protection and highlighting the need for protection, because this concrete approach helps. That's the first comment. So in other words, I could say, I'm not asking you, it's a comment. Are there groups in respect of which, at this point in time, one could use the channel of the SDG to say, this group is in need of protection and we need to generate attention to them. And then related to, we're here in the Academy of the Nuremberg Principles Academy. And I want to raise this following issue, if I may. From the point of view of the law, the need, as the world is evolving, the need for executive authority in the world. Now, executive authority, what do I mean by this? Some of the figures we have seen, we're living in a world of sovereign states, yes, and some of the figures that we have seen are that millions of people could be forced to flee frontiers and to seek refuge into other countries. And now these are human beings in need, etc. And these are human beings in need, etc. And the principle of sovereignty will say, we're seeing this play out in people seeking to move to Europe, see people seeking to move to the United States. Now here's my question. Is there an authority in the international community that might be, that would need to be able to take executive decisions for the protection of people? And where I'm headed is, there's only one organ that I can think about, and that's the executive authority of the Security Council. So thinking now about the future and using the SDGs to think about the protection of people, I want to place before you, and I want to place before the distinguished director of the Nuremberg Principles Academy, this issue. We need new thinking and this issue of the executive authority of the Security Council. Forgive me for kind of lecturing you a little bit, but I thought, yeah, thank you. Yeah.
Thank you, Dr. Ramcharan. Can we have another intervention? Is there another intervention? All right, if there is not, I'm going to turn it back to our panel, but as I ask them to make their closing remarks, I want you to think through, to weave it into the theme of SDG 16, and think about the governance failures in your various areas that you have spoken about in thinking through one most important thing that can be done in terms of improvement, in terms of what the SDGs could actually do in that area. When we think about SDG 16, you're thinking about justice, you're thinking about peace, you're thinking about inclusivity of these vulnerable groups that we've spoken about, and we're thinking about strengthening of institutions. Which institutions do we need to strengthen, for example, so that we can get the outcomes that we were talking about yesterday? So in your closing remarks, if you could try to weave all of that in. Thank you. I'll start with you, Sebastian.
Thank you. So I said earlier I had some ideas of how to combat impunity for environmental crimes. I'm sure you've all been waiting. Yes. So here I'll end with those. And instead of a new authority, I'm going to quote some old authorities. So in 1646, Grotius wrote that if trees could speak, they would cry out that since they're not the cause of war, it is wrong for them to bear its penalties. And then a more recent authority or proposal in 1995, there was an ECOSOC resolution which urged member states to consider creating a convention that would penalize the most serious forms of environmental crimes. And more recently, there's been this civil society campaign trying to, or calling for states to add the crime of ecocide to the Rome Statute of the International Criminal Court. So I'm actually not in favor of that idea. I think the ICC already has a lot on its hands, already has lots of challenges. So I would instead propose two things. So one would be that in their bilateral aid programs that industrialized nations could prioritize helping developing countries to implement the environmental rule of law, helping them to train and create, train specialized prosecutors and judges to deal with environmental crimes, adopt legislation penalizing environmental offenses. So that's one clear proposal. But the other more long-term idea, so this is my pitch to anyone who wants to move forward with this idea, I think creating a standalone convention along the model that exists for the conventions on corruption or torture is the better model here. And this convention could be one that would be so focused on environmental crimes. It would do a number of things. One, it would create a list of offenses. What are the most serious environmental offenses, along the lines of what the Council of Europe has already done in Europe in this EU directive. Two, it would commit states to enacting these crimes into their domestic laws, to investigating and prosecuting them. Three, it would commit states to cooperate with other states in investigations and prosecutions. Four, it would identify the grounds under which states might use extraterritorial jurisdiction. And then finally, it could establish a mechanism whereby states might receive funding and technical assistance and capacity building to strengthen their ability to investigate and prosecute environmental crime. So that's my pitch. If anyone's interested in following up with this idea, I'd be happy to work with you.
Thank you very much. I think you've posed some very challenging questions that I'm not entirely able to answer, but I think maybe I can also just pick up on the comment that you've made and what is an ultimate solution for refugees and what could an executive power perhaps do. There have been basically three suggestions on how to manage the refugee issue because as we've all seen, basically there's an exhaustion with refugees, there's very little responsibility sharing globally, and people are not willing to take accountability. So one suggestion has come from Alexander Betts and from Oxford, which is to create zones for refugees that increasingly focus on being export zones where there's increased work opportunities and trade opportunities. And this has been enacted first in Jordan with the zones that they've created. And the idea here is to increase self-reliance for refugees where they are. There have been a lot of challenges and that not as many refugees have actually become employed within the zones that they've created. And there's been a lot of critiques and criticisms that this is creating marginalized sort of communities and segregation within these zones. A second, more perhaps utopian or philosophical idea has been proposed by Robin Cohen and Nicholas Van Heer on refugia. And the idea here is to create a state of refugia, which would be a place where refugees can find a home somewhere in the world. Of course, the exact place of where that would be, what land that would be, is not clear, but it's more of a philosophical idea of what refugia would be, what it would look like. And you can read more about it in the various articles they propose on the idea. Both of these are, of course, very challenging. And the third idea, I think, which could be perhaps the most clear-cut for what an executive power could do, would be to create a global redistribution system, where all countries in the world are responsible to take X number of people. There's a type of quota system that's developed based on different levels of criteria, and countries need to take their responsibility for refugees. And there would need to be then, of course, some type of a punishment or enforcement mechanism for people who don't take their accountability. There's, of course, challenges that we can also envision within such a system, but this would be a way to have an enforcement for getting people to other countries where they can be resettled globally around the world and not just living in refugee camps. So I think maybe this is one way to conclude about possible ideas that could maybe be executed for refugees.
Thanks. I think the governance failures that you mentioned, the SDGs definitely have a role, I think, to play, and I have a couple of thoughts on how. One, it picks up on the question that I was asked about what the SDGs can do for human rights. I have talked a lot about the need to challenge the disconnects, to challenge the lack of policy coherence, which I think results in governance deficits and a lack of accountability. Looking at the SDGs as a possible frame of response, one has to recognize that they are universally accepted, at least, and that all sorts of actors invoke them and echo support for them. So in some sense, maybe they are a frame for this joined-up thinking and coherence that I've talked about, notwithstanding the lack of legal accountability and the other problems that I mentioned. I think in pushing for that joined-up thinking and in that policy coherence, I think it's also really important to respect and retain the division of labor in the international system, because I think people get nervous within IFIs, for instance, but also in the human rights community, the idea that we're just going to meld it all together and that the roles and expertise and mandates get completely suffused with one another. And I think it gives people a lot of comfort and makes a lot of sense that there be this division of labor, and in that spirit, a recognition of the distinct and complementary roles that different actors play. What I've also thought, though, is that in that spirit, there's still room for a lot more interinstitutional cooperation, particularly now that we have this enhanced recognition of the importance of human rights principles in the SDGs, for example, that weren't there in the MDGs. Concretely, this could be participation in one another's processes. I'm thinking of the UPR or in the deliberations of the Human Rights Council where they're relevant. The relationship agreement that the World Bank and other specialized agencies have concluded with the UN specifically envisages exchange of information and a far more active dialogue between the different parts of the system. We've had experience on data and on human rights indicators, very concretely being part of the intercommittee exercise on developing a guide on human rights indicators within OHCHR. And I think with that would come a recognition that there is a space and even a benefit to bringing in the expertise of the human rights bodies, for example, or human rights agencies, into specific concrete deliverables and processes, instruments, documents that govern how we do our work in development. Thanks.
Thank you very much. Please join me in thanking this brilliant panel.